Intellectual property is proudly brought to you by Adams & Adams, rooted in 100 years of excellence in intellectual property law.
Good evening, I'm Stefan Lamprecht. Welcome to the show. On intellectual property last week, we reviewed some of the basic types of IP, such as patents, trademarks, and copyright. Tonight I'm joined in the studio by Alan Lewis, a well-versed IP practitioner from Adams & Adams Attorneys, to chat about the commercialization of intellectual property. Good evening, Alan.
Evening, Stefan.
Alan, a lot of times when people talk about intellectual property, they talk about registering a patent or patenting and so forth. But surely, given what we spoke about last week, the number of types of IP, there's a bigger process involved. Can you tell us a little bit about that?
Sure. You're quite correct in saying that it is a process, and it's an ongoing process. There's no start, there's no beginning, there's no end. It continues. It's a continuum of events, starting, of course, with the initial idea or innovation, which right from the beginning should be linked, should be tied into the business of whatever entity it is that...
So if I'm the businessman, I got to decide what is it that I would like to do, what is the purpose behind this whole innovation, and then go through this creative phase, and then go into the next steps of IP management.
Precisely. And we cannot emphasize too strongly that there is this entire process that is linked to the strategy and the business of whatever is the objective is and whatever the end result is intended to be.
Do you find a lot of times that people come to you and say, should I patent this, and then expect you to give them an answer?
Unfortunately, far too often.
Okay.
And the decision whether or not to file a patent application is really a business decision. Okay. It must be based on the potential commercial value that is perceived by the people involved.
Okay. So once I've finished with that stage as a business person, I've decided what it is I would like to do, gone through the creative phase, and I come speak to you, for example, what happens next?
I would get details as to what your plan is, what your idea is. I would then file a patent application, normally a provisional specification in the first instance in South Africa. And then, of course, it's up to you.
Yeah.
Because I cannot, I don't have a magic wand.
Yes.
I don't have a golden goose under my armpit.
Okay. Okay, so I've got to decide what's the next step. Do I want to go further than that? What does my business strategy say? Maybe do some feasibility into the product and so forth. Once you've gone into that securing of the appropriate IP rights, such as a patent or a trademark and so forth, what then? What happens thereafter?
Let's distinguish between technology on the one hand and branding on the other.
Okay.
With technology, excuse me, the aim is normally to provide goods for sale. That's normally the common event that happens.
Okay.
There are certain instances where it is a method that is being protected,
okay,
rather than equipment or goods or apparatus.
So I've got a new process for deriving revenue through a sales process, or maybe it's the way that I structure the business. Can I patent something like that?
In South Africa, unfortunately, the answer is maybe.
Maybe. Okay.
It's a very convoluted, very involved
okay,
legal argument as to whether or not. However, if you don't file a patent application,
yeah,
there's no other way to protect it.
okay.
There is only one way in which you can protect that kind of activity, and that is by means of a patent.
Okay. We hear a lot of people talking about commercialization of intellectual property. How would you define that concept? What does it mean?
Making money.
Making money.
Making money.
Okay.
And that must be the prime objective. The basis of using the intellectual property regime is to make more money than you would otherwise make. And there are various ways in doing that. The basic way is to use the intellectual property, be it a patent, as a barrier to entry.
Okay.
In other words, to give yourself some kind of foothold, some kind of monopoly position.
Or if it's a trademark, for example, I brand something 2010 World Cup Guest House, for example, and then use that as a barrier to entry. Would that work?
Not in South Africa at this time, no,
Okay.
because of what's happening with the protection of the 2010 and Soccer World Cup football. That's all very well protected, all very well nailed down.
Okay. So they've set aside a number of brands that they believe to be representative of that event.
Proprietary
Okay.
to FIFA.
Okay. And other models of commercialization, you've mentioned this one of keeping people out, a barrier to entry. What else?
Right. The barrier to entry approach is the bottom approach.
Okay.
It's the defensive approach.
Yeah.
The beauty about intellectual property is that it can be leveraged, it can be manipulated, it can be exported.
Okay.
And if it works in South Africa, why shouldn't it work anywhere else in the world? There are certain technologies that are peculiar to South Africa, but many technologies are exportable.
Yeah.
And the intellectual property, the underlying intellectual property right, be it a patent or a registered design or whatever, can be leveraged in a number of ways.
Yeah.
The most common way is by licensing.
Okay. So licensing typically like we would see in the franchise model, or if I produce something like an electronic gadget and I put Dolby surround sound as a trademark, are those examples?
Those are very, very good examples.
Okay.
And that is the way in which South African business can get a world footprint.
Okay.
And I may mention that South Africans are only now entering the world arena. And the name of the game internationally is you patent.
Okay.
And that is, unfortunately, because it is a fairly expensive exercise to get a patent portfolio in a number of offshore jurisdictions.
Okay.
But that's the name of the game.
Okay.
And I've recently been approached by several public companies who are now realizing that if they want to expand internationally, if they want to go offshore, they've got to play the game the way it's played offshore, and that is by acquiring patents.
Okay.
If you don't have a patent, you really have, other than relying on trade secrets, if you don't have a patent, you really have very little to negotiate with, to sell, to find finance, to negotiate a settlement, of course, in infringement proceedings, because it very often happens with litigation that there's a trade-off.
Thank you very much, Alan. Alan Lewis from Adams & Adams, thanks for joining us tonight. Tune in again same time next week as we look at the role of intellectual property in maximizing shareholder value for the oil giant Sasol. Until next time, from me, Stefan Lamprecht, good night.